Hi friends, and welcome to the Art of Estate Planning podcast. I'm Tara Lucke, founder of the Art of Estate Planning, and my mission is to inform, inspire, and support you in your estate planning practice. Before we dive in, a quick heads up. The primary purpose of this podcast is to educate and inspire. The views expressed by me and any of our guests are for information purposes only and do not constitute legal, taxation, or financial advice. If you act on anything from this episode, please make sure you can back up your advice by relying on primary sources such as legislation references and case law. Welcome to episode 46. I am Tara Lucke, founder of the Art of Estate Planning. Thank you so much for tuning in today. Now, our topic for today was actually inspired by a question in one of our weekly hot seats for the TT Precedents Club. So you've probably heard me mention it before. Every Thursday in the TT Precedents Club, we get together and we have a live Zoom call, and people can ask questions for myself or the other members in the club on the call to answer. And it's a real, brains trust mastermind. We've got people of all different experience levels. No question is too silly, and it is just such a supportive environment. And one of these questions came up, and I just thought it was a great one to just talk about generally as well. So the question is, my clients who have engaged me to prepare their wills, they already have an existing family trust. So do I need to set up an additional testamentary discretionary trust for them? Or can we just leave everything into the family trust that's already in existence? And it's such a fair question. And I can definitely see that many clients would ask this as well, because they're like, why would we reinvent the wheel? We already have a trust. So I thought in this episode, we can compare the difference between an inter vivos family trust and a testamentary discretionary trust. And look, before we go into the differences, there are some major similarities between them both. They're both discretionary trusts, which means the entitlement to receive income and capital from the trust of the beneficiaries, that is at the trustee's discretion. So the beneficiaries just sit there on their hands, waiting patiently, behaving themselves, waiting for the trustee to choose them to receive some income and capital that year. So it is fully discretionary at the discretion of the trustees. But there are some other differences, and I guess I'll just spoil the ending in that you definitely should set up an additional testamentary trust rather than using the family trust already in existence. Okay, and that comes down to managing risk, but particularly the tax treatment. So in episode 45, we talked about accepted trust income treatment and how testamentary trusts get a tax treatment that is not available in any other type of legal structure in Australia. It is truly special. The government recognizes that somebody died for the testamentary trust to come into existence, and you only get this special tax treatment with a testamentary trust, and it's particularly advantageous over existing family trusts. So let's perhaps start there. Okay, so with the accepted trust income treatment for testamentary trusts, minors are taxed as adults. So that means they get their full tax-free threshold of about $18,000 at the time of recording, and then the marginal rates from there. So at the time of recording this, minors can get about $22,500 tax-free of income from the testamentary trust. That's each minor each year. Under the family trust, minors have to pay penalty tax rates, over $417, 417, compared to $22,000. And the tax rates are different. with the testamentary trust, when they earn over that 22,500, it's just like a 16% tax rate, I think, on the income above that. And then it steps up like the normal tax rates. With the family trust, everything above the 417, it's about 66% tax and like an extra 50% tax penalty until they get to about 1,300. And then from there, I think it's like 46.5%. So there's no way that you would want to distribute income to minors from an existing family trust. So the starting point is the tax treatment of the testamentary trust is just so much better. One other thing that I didn't talk about in episode 45 is about accumulating income. And I got to the end of that episode and I thought, I probably should include it. It's relevant, but I thought everyone had enough about tax. So I'm going to talk about it now. In the episode 45, I explained that trusts, whether it's a family trust or a testamentary discretionary trust, they're a flow-through vehicle for tax purposes, unlike a company. So like the company earns its income, pays its tax, and then the money just stays in the company unless they choose to release some profits through dividends or pay out a loan or something. But trusts, the status quo or starting point is that the income is allocated and all of it is distributed out by each financial year. So everything that comes in, less the expenses, goes out of the trust. It doesn't hold on and retain profits or income. And the reason historically is because accumulated income in a family trust is taxed at the trustee's penalty rate. So you don't do it because it's a penalty top tax rate. But testamentary trusts do have special treatment where under section 99A sub 2, you can actually apply to the commissioner to exercise their discretion that it would be unreasonable for the income accumulated to be taxed at the trustee's top marginal rate. So it's not just a standard you're straight up entitled, but if there were genuine reasons why, then, you have the option to apply to the commissioner and get it. I think you do it through a private ruling. I've not actually ever had to go through that experience myself. But again, you have the potential to accumulate income in the testamentary trust that you do not have under a family trust. So on all measures, the testamentary trust just blows the family trust out of the water when it comes to tax treatment. They are just so far superior, and they are a very special vehicle. Not everyone can get them. You can't just go and set up a testamentary trust now to operate straight away, right? I'm sure you all know this, but just to make it abundantly clear, the testamentary trust is in the testator's will. It has to be in there when they die. You put it in the testator's will when they make their will. It is dormant. Nothing happens. It doesn't exist. It's just lying there dormant or sleeping, waiting to be enlivened and commence when the testator ultimately dies. So you cannot just go and go, I'm going to go off and see an accountant and set up a testamentary trust. It doesn't work like that. They only can start when somebody dies. And because of this connection with such a tragic event of a person's death, that is why we get the tax treatment. So you only get one shot at having them for each person. They only get one chance. It has to be in their will before they die. Obviously, you can have as many as you want, but if you don't get around to doing your will and you die, then that's it. You lost that opportunity. Versus a family trust, you can go and set up 10 each day if you like for your whole life. There's no limit on anything like that. So testamentary trusts are a very special protected vehicle. So if you get the chance to do one, absolutely go for it. Especially, the advice I'd be giving to the person who asked this question in our hot seat, because they use the Art of Estate Planning Precedents, and our precedents have a pathway in there for the testamentary trust to be optional if it turns out they don't need it at the date of death. So at that point, I'd say Plan for all the contingencies. Better to be safe than sorry. Put the testamentary trust in the will. So a couple of other differences. I've actually got in the show notes a flyer that you can download, just comparing the family trust with the testamentary trust. So a few other differences. They're set up by different documents. So if you're familiar with a family trust, you'll know that they're set up by a trust deed, or they should, a good one, should have trust deed with all of the terms. The testamentary trust doesn't usually have like a separate trust deed. It's actually the will of the testator, which is the trust deed. In terms of the vesting date, the family trust will start from the date of establishment, whereas the testamentary trust, it too does start from the date of establishment, but that will be the date of the testator's death, not the date that the will was signed. So in this scenario, for instance, our family trust that our clients already have, its vesting date is already sooner. It's always going to be earlier than the vesting date of the testamentary trust. So its perpetuity period, let's say it's 80 years, it is already starting. Imagine a clock ticking down, or a hourglass. We're already every day, that hourglass is getting lower and lower and lower in terms of the sand and that perpetuity period running out. Whereas with the testamentary trust, it's on ice. It doesn't start ticking down until the testator actually dies. And remember, with our tax treatment and our asset protection, this is not just for one generation. These are ongoing wealth accumulation vehicles for multiple generations. They're so powerful. So the longer we can have our trust running and operating, the more tax that whole family and bloodline saves, the more protection they have over their assets. So for me, having that vesting date ticking down at a later date and putting it on ice for now is really powerful. Our tax treatment for minors is different. Accumulating income is different. They are both required to make a family trust election, though, that's also relevant to look at in terms of what are we inheriting with the trust. So this family trust is already in existence. It might already have made decisions about its assets, its contracts and dealings with third parties, its tax position, that may not actually be something we want to inherit or pass on or contribute more assets to. So, for instance, with the family trust election, where you have, I think franking credits more than $5,000, or you want to carry forward tax losses, I'm just going off the top of my head here, so there could be other reasons you need a family trust election. You have to make an election to limit the people who can receive distributions from the trust. So they basically say you have to nominate a key individual, and anyone in their family who's related to them, only those people can receive distributions from the trust, and anyone outside of that family net will pay an additional tax. So it's usually fine because it's, goes down to the whole bloodline and the lineal descendants, which is what most people want to do with these trust structures. The idea is it's sort of to stop you from selling the trust to a completely unrelated person and changing up the beneficiaries and basically selling the trust out of the family group. But with older trusts, it might be that this existing family trust named someone who is the grandfather or a person who is deceased or something as the key person from which the family group is radiating around. And in however many years' time, 20 years' time or something, it would actually make sense to name a different person, a younger person, to be in that the key person for that family group. So, look, I don't know. It's not something that comes up all the time, but my point is we are inheriting decisions made in this existing family trust rather than getting a clean slate. On that same note, what is the terms of the trust deed. Has this trust been going for 10 years? Have there been progress in terms of how we draft our trust deeds in that 10 years' time that would make more sense? Are there actual errors or problems in that original trust deed? Like if I am doing anything with a client's family trust and putting more assets into it, I want to go through the terms of that trust deed with a fine-tooth comb and make sure there is absolutely no problems, issues, validity concerns, drafting errors, anything like that. And that I'm happy with the variation power, I'm happy with the default capital distribution, that there's just absolutely nothing wrong with that trust deed, because why would you exacerbate, if there is a problem, why would you exacerbate it by injecting, all the inheritance into it as well? So, it sounds simple. It's actually, I think, from the lawyer's perspective, more work to do a basic will that gives the assets into an existing family trust than it is to do a testamentary trust, especially if you've got your precedents dialed in with your software integration. Like, at the Art of Estate Planning, we integrate with Leap, Action Steps, Smokeball, Clio. So generating a testamentary trust will, that's not the hard part. The hard part is the client strategy. So the hard part when you're gifting to a existing family trust is doing an extensive audit of that family trust. All the changes of trustee, all the change of appointor, successions of control, are those all squeaky clean and in order? Are the beneficiaries correct? The other thing to think about too is, what has that trust been doing? Has the trust just been holding passive low-risk assets, or does it own risky assets like property, commercial property? Is it running a business? And if it has any exposure to risk, do we want to be throwing and injecting in passive low-risk assets in there? The other thing to think about is, what about super? And we have to be really careful if the estate includes super to be injecting that into a trust, because if the beneficiaries who could have received that super, people who are death benefit dependents and could have received it tax-free, if they had received it outright from the super fund, but they're going to receive it through a trust, then what we actually need is a super proceeds trust that narrows down the range of beneficiaries of that trust to only people who are death benefit dependents for tax purposes at the date of death. So that will not be the case if you're putting the super into the family trust. You'll pay tax on it that you wouldn't have paid if you'd paid it to a super proceeds trust or directly to the beneficiaries of the super fund. So there's a lot of things going on there. I would not put an inheritance into a trust that had ever carried on a business or owned commercial property or anything like that, because we are mixing our risk profiles of assets. And there's a huge advantage in having a clean skin, fresh slate for those low risk passive assets. So yeah, be really cautious of those historical issues, especially if the clients are driving this because they want simplicity. It's actually not as simple as it sounds. I think there's actually quite a few concerns. So I'm just going to take a break there. I'd love for you to listen to one of our clients, Jono, and the beautiful things he has to say about the art of estate planning.
Hi, my name's Jono and I'm a co-founder of Balance Family Law based in Canberra. A few years ago, we decided to invest in the art of estate planning, wills and testamentary trust precedents to expand our estate planning service offering to clients, and it's been one of the best investments that our firm has made. The precedents are really easy to use from a drafting perspective and also when it comes to advising clients, and they're also really easy to use when training staff. We receive lots of positive feedback from our clients on the documents, as well as from other professionals like financial planners and accountants. The precedent packs provide not only wills precedents, but also template letters, file notes and other documents that you'd need in your estate planning practice, and allow us to provide simple and complex estate plans to clients really easily, especially ones that include testamentary trusts. The Art of Estate Planning also offers other precedent packs for letters of wishes, family trust succession, and company self-managed super fund and trust powers of attorney, all of which we've invested in and have been really good for our clients and our firm. Investing in the Art of Estate Planning Precedents, as I said, is one of the best decisions our firm has made for our estate planning practice. So if you've been toying with the idea of doing so, we highly recommend that you do.
Thank you, Jono. So I've talked about the considerations in terms of your strategy, but now I want to talk about the drafting considerations. So let's say you've considered everything and you have decided that, we are going to use like a basic will and gift the inheritance into an existing family trust instead of using a testamentary trust. So here's a few things to think about in terms of your drafting. So do your clause to draft it. I recommend, in the TT Precedents Club, in our clause library, we do have a clause for this, and we just factor in things like if the trust has been vested prior to the testator's death, the testator made their will 10 years later, they all decide to wind up the trust. The accountant hasn't looked at the will. No one's remembered this strategy about the will, which, would never happen in the scenario of a good accountant who's fully dialed into this. But these things happen. Then you need to have a contingency plan, a gift over, a plan B in case that trust no longer exists. So where is it going to go then? Secondly, factor in the succession plan for the trust. So the trust is in existence now. As we know, when our testator dies, all that happens is they stop being a controller of the trust if they were one, and they need a replacement. So you do need a succession plan in place for that trust. I strongly recommend using the deed of successor plan, building in contingencies there and making sure that it addresses both death and incapacity. A lot of people want to just put in a quick clause in the will to nominate a successor controller on the controller's death, but that only deals with half of the succession planning scenario. You still have no plan in place for that family trust if the person loses capacity, because the will only applies on death. So don't do it in the will, do it in the deed of successor. And we've got a great episode on that. Episode 35. Go and listen to that one if you want to dive into that a little bit more. So gift over in terms of drafting it and get the control of your trust right. Consider all of those historical issues as well. So I do have a downloadable in the show notes if you want to have a quick look at the comparison. Another thing which I'm not going to dive into today, but is thinking about if the assets that you're gifting under the estate plan is a principal place of residence and is going to continue to be someone or a beneficiary's principal place of residence, really looking at how are we addressing the capital gains tax exemption and any land tax that is going to be incurred on an annual basis. So again, there's different rules for testamentary trusts and these arrangements being established under a deceased estate and a will versus an existing family trust. So that would also be something to think about. Look at the assets that you're actually gifting. Superannuation, family homes, which for most people is the bulk of their assets. Be really careful about that as well. So hopefully that's given you some food for thought. I think I've covered off everything. I'm sure I might think of more considerations. My main takeaway is this is not the easy way out. And I just don't know why on earth you would forfeit that accepted trust income tax-free treatment for minors that the testamentary trust gives you in favor of simplicity with a family trust. Maybe if there are just no children ever contemplated, they just don't need to worry about that, and the estate in the personal estate is very small, then maybe I'd think about it then. But most of the time, you only get one shot. If in doubt, use the testamentary trust. Thank you so much for tuning in. I really appreciate it. If you've got any thoughts on this, you can always continue the discussion in the Art of Estate Planning Facebook group. I would love to hear from you, and I will see you next time. Thank you. You might have heard me mention our TT Precedents Club membership a few times throughout the episodes now. So I wanted to share a little bit more information about what it is and how it works. The TT Precedents Club is a membership for Australian lawyers. Whether you're an estate planning specialist, an early career lawyer, or experienced in another legal area, and you want to add estate planning as a complement to your existing services, it doesn't matter, as long as you're curious about estate planning, keen to learn and share in our estate planning mastermind group. Every Thursday we meet at 1 p.m. Australian Standard Time or 2 p.m. when daylight savings is on, and have a live Zoom call where our members submit their questions in advance. We can workshop your client scenarios, research your tricky questions, and even draft clauses for you. It will make you feel like you work in a firm with 50 other estate planning partners who are all there to support you and share their collective knowledge with you. There is no reason to feel intimidated. Our community is so supportive, friendly. There are no silly questions ever. Not only do you get access to our awesome weekly hot seat calls, but we have an exclusive Facebook group. So if you thought our free Art of Estate Planning group was good, then this group is on steroids. You also get discounts to the Art of Estate Planning Precedents, a huge back catalogue of training, in-person networking meetups, a will drafting clause library, and other practical resources to help you in your estate planning practice. The membership is month to month, so you can join for as little as 1 month and then cancel anytime. There is no lock-in period or a minimum join time. Join over 280 Australian lawyers in Australia's best estate planning community. Thank you for listening to this episode of the Art of Estate Planning podcast. If you want more information about today's episode, make sure to check out our show notes. And if you liked what you heard today, don't forget to subscribe and leave a review. Your reviews help us reach more listeners and support more estate planning lawyers. I acknowledge that I recorded this podcast from the lands of the Tarabellang Bunda peoples. I also want to acknowledge the traditional custodians of the lands on which each of you are listening and watching from today. We pay our respects to elders past, present, and emerging, and celebrate the diversity of Aboriginal and Torres Strait Islander peoples and their ongoing cultures and connections to the lands and waters of Australia.